Good morning, friends. Namaskar, Sat Sri Akal, and Adab. This is my 269th video, and this will again cover the issue and for the first time, Cantonment House Accommodation Act 1902 1923 was a culmination of the grievances of house owners, bungalow owners, and the act gave special powers. The Secretary of State India oblique local self-government, bungalow owners or grantees. Bungalow owners will not be addressed grantees, but they will be called owners. This act very clearly says no bungalow could be appropriated under the same act if the document of grant were forthcoming, and under such condition the commander, the GOC, could not veto or annul the sale purchase of such bungalow till the same is resumed as its terms of grants. But if the same terms of grants were not forthcoming, the notification of the same act in any cantonment does not empower the cantonment authority under section 3 to apply the said act on that bungalow for appropriation. It could only be resumed first, and then this act is applicable. There has to be a written instrument between the house owner and the authority for the appropriation of the bungalow for military officer. The same act gave a relief to bungalow owners that no notice can be issued. Now let's read what does the Cantonment House Accommodation Act, either 1902 or 1923, under section 11C. What does it say? No notice under section 6 and 7 to be issued if the owner is in self occupation of bungalow. Section 10C. No notice under section 7 to be issued if the owner is in self occupation. So here it clearly restricts that no owner who's in occupation is to be issued a notice. The same act gave the bungalow owner a relief that if proved by any court degree, then either rent the same bungalow to the local self government or sell the same bungalow, in other words, to the local self government through Secretary of State India, who will purchase the same bungalow. Now, under section 14, under section 13, it spoke similar things in 1902 and 1923, that this all could only be done after a complete satisfaction of the local self-government, the so-called cantonment magistrate, or today's cantonment executive officer, or proved by a court degree that the bungalow was erected under any regulation. Now, what does this mean? This para or part means? This means on a presumption, it has already been presumed by the Union of India and the department that we are a grant under some rule and regulation. So, if entire cantonment is under some rule and regulation, that means the House Accommodation Act cannot be applicable within the boundaries of that cantonment, because it very clearly says either you be on this side or either you be on this side. Now, I have a notification for Ambala Cantonment in Punjab Gazette 1904, page IP 816. So, we as bungalow owners, do we fall under the jurisdiction of the House Accommodation Act? This needs to be brought to the court. And who will bring it? Either your advocate will plead, either you have those laws in your hands, then only can you plead. Now, talking of Ambala, I can very clearly say that we have a bylaw 30 on page 138 of the bylaws of Ambala Cantonment, 19th April 1926, number 12062, in exercise of the powers conferred by subsection 1 of section 3 of the Cantonment House Accommodation Act, the Governor General Council, with the previous sanction of the Governor General in Council, is pleased in supersession of previous notifications on the subject to declare the said act to be operative in those areas of Ambala Cantonment, the boundaries of which are described as such. So this is the whole dimension. And we made a plan, and the same plan has been exhibited in the court either. Now, what does under section 13? The Secretary of State India is supposed to purchase the bungalow, which is also mentioned in GGO 179 of 1836 in its clause 7, which states house claimable for purchase or hire at the option of owner. A committee of arbitration, all houses in military cantonment being the property of persons not belonging to the army, which may be deemed to be by the commanding officer of the station suitable for an accommodation of officer, shall be claimable for purchase or hire at the option of the owner. So, where is this difference between an House Accommodation Act or a GGO Regulation 7? But what happens? In either cases, neither do we plead this, neither do we plead Regulation 7, and we are hampered under Regulation 6. This clause, the words were further substituted in order number 700 on 3rd July 1855, being the property of a person not belonging to the army. So this clearly shows that the government of that day, or the Secretary of State India, had been purchasing bungalows in cantonments if they were wanting. So, are we to say that all these bungalows in our cantonments were first resumed and then they were given to the military officers and then they were subjected to the regulations? This is all need to be understood. For Ambala, I have a full list of more than about 14 to 15 bungalows which were purchased by the government. Now, what does the Constitution of India say? Under 7th Schedule, Entry 3, List 1, scope of legislation on regulation of house accommodation in cantonment area. Whether can be confined to houses acquired, requisitioned, or allotted for military purpose. Scope of the expression regulation of house accommodation in entry 3 list 1, competency of the state legislature to legislate on relationship between a landlord and tenant in the area. It says in one, when power is granted to Parliament to make laws for the regulation of house accommodation in a cantonment areas, there are no qualifying words to indicate that the House Accommodation Act, which is to be subject to such legislation, must be accommodation that has already been acquired, requisitioned, or allotted to the military. There is no reason to narrow down the scope of regulation on regulations of house accommodation and confine it to houses which were acquired and are actually in possession of military authority or military officer. The power to regulate house accommodation in the cantonment area, irrespective of its being owned by or in possession of the civilian. In fact, if a law were to be made for the first time under this entry, all the houses would be either vacant or occupied by owners or occupied by tenants of owners under a private agreement, and the law, when first made, will have to govern such houses. The scope of expression regulation of house accommodation is this in this entry cannot be confined. This entry gives the power to Parliament to pass legislation for the purpose of directing or controlling all house accommodation in cantonment areas. Clearly, this power to direct or control will include within it all aspects as to who is to make the constructions, under what conditions the constructions can be altered, who is to occupy the accommodation, and for how long, and on what terms is it to be occupied, when and under what circumstances the occupant into cease to occupy it, and the manner in which the accommodation is to be utilized. All these are ingredients of a regulation of house accommodation, and there is no reason to hold that this word regulation has not been used in this wide sense in this entry. The parliament was given the exclusive power to legislate in respect of house accommodation in cantonment areas for regulating the accommodation in all its aspects. This power reserved for Parliament is to be exercised in respect of house accommodation situated in cantonment areas only, and not other area, the legislative power in respect of which is government by entry either in list 2 or in list 3. This relationship of landlord and tenant in respect of house accommodation situated in cantonment area is clearly covered by the entries in list 1. In continuation, the effect of entry 3 of list 1 is that Parliament has the exclusive power to make laws with respect to the matters contained in that entry, notwithstanding the facts that a similar power may also be found in any entry in list 2 or list 3. The general power of legislation in respect of relationship between a landlord and tenant exercisable by state legislature either under entry 8 of list 2 or entry 6 and 7 of list 3 is subject to the overriding power of Parliament in respect of matters in List 1. So that the entry 3 of List 1 is that on the subject of relationship between landlord and tenant insofar as it arises in respect of house accommodation situated in cantonment areas, Parliament alone can legislate and not the state legislature. No anomaly arises in holding that the exclusive power of Parliament for regulating of house accommodation, including control of rents in cantonment area, has the effect of making the legislative powers conferred by list 2 and 3 subject to this power of Parliament. When such orders are passed by the highest court, Supreme Court, full bench judgment, it has left no explanation that the bungalows falling within the notification. It is only the parliament which can alter or amend the structure of this act called the House Accommodation Act 1902 1923. This part has been read from a paragraph of a Supreme Court judgment when an interpretation was being done on the relationship. We need to understand, some people talk of House Accommodation Act that was only for hiring of bungalows for military officers. No, it even says you can only be hired if you are not in either of the regulations, and if you were in the regulations you should have been either resumed, because this act overrides everything. And once you fall in this act, resumption or notice cannot be issued if you are in self possession. Further, even if you are willing to leave, the Secretary of State or Government of India has to purchase your bungalow. Friends, let's interpret this. Let as many advocates and senior counsels read this through, and then we can decide what is good for us and what is bad for us. I'm not saying what I'm saying is the Bible or the thin line of the end. No, it is a debatable system, because the interpretations, when we talk of whether we are a grant, whether we are governed by Cantonment Act, whether we are governed by House Accommodation Act, everything needs to be interpreted. That is why I say let's talk. Thank you. Good day.